In the American legal system, government does not create rights. Your rights and your sovereignty exist before the government does. The state possesses zero independent residual power of its own. Because the government has no inherent power, every ounce of authority it exercises must be granted to it from an external source. Thomas Paine framed the origin of this authority with absolute precision. He wrote, "All power exercised over a nation must have some beginning. It must either be delegated or assumed. There are no other sources. All delegated power is trust, and all assumed power is usurpation. There is no third option. Public officials do not have a secret menu of implied authority to draw from. Every valid action taken by a government official must trace directly back to a specific, express grant of power from the sovereign people. If a specific power is not explicitly granted in the constitutional charter, the government simply does not possess it." Any attempt to exercise an undelegated power is, by definition, an act of usurpation. People often say, "I have my constitutional rights." Structurally, that phrasing is backward. The Constitution acts as a restrictive leash on the agents of government. In 1868, legal scholar Thomas M. Cooley explained that a written constitution is, in every instance, a limitation upon the powers of government. This principle is codified directly into the framework of the United States through the 10th Amendment. By stating that undelegated powers are reserved to the states respectively or to the people, the text ensures that any power not explicitly surrendered remains permanently with the sovereign. In law, this triggers the doctrine of casus omissus. If the constitutional charter is silent on a specific power, that silence is a deliberate prohibition, not an oversight. Cooley established the rule of construction here. All presumptions are strictly against the government and entirely in favor of the rights retained by the citizen. The result is a closed system of power. Government cannot manufacture new authority out of constitutional silence, regardless of institutional convenience or a declared emergency. This structural limitation applies heavily to the legislature. Lawmakers do not own the sovereign power they wield. They are strictly bound agents. Philosopher John Locke defined legislative power as a fiduciary trust, held conditionally on behalf of the people. In a fiduciary relationship, the trustee is strictly bound by the terms of the trust. They can never treat the entrusted power as their own property, and they can never act as the master. Because it's a trust, Locke noted a hard limitation. The legislative cannot transfer the power of making laws to any other hands. The boundary exists because the people granted the legislature authority to make laws. They did not grant authority to make new legislators. Breaking this trust has severe consequences. When the legislature acts outside its bounds, it dissolves the legitimate, lawful authority of its actions. The moment a legislature attempts to subdelegate its core duty, it abandons its role as a trustee and operates entirely outside the constitutional system. The American founders translated Locke's political philosophy into practice through the inherited, concrete rules of common law agency. The controlling rule is expressed in the maxim, potestas delegata, non potestas delegari. A delegated power cannot be again delegated. In standard agency law, a delegate cannot lawfully devolve their entrusted duty onto a subagent without the explicit consent of the principal. Applied to the modern administrative state, this exposes a mechanical failure. When Congress creates an unelected bureaucracy and authorizes it to write binding regulations, that is an attempted subdelegation of legislative power. A derivative power can never be greater than the original source from which it derives. The legislature cannot give away what it only holds in trust. Any legislative attempt to transfer lawmaking authority to an administrative agency fails the fundamental test of agency law. The transfer itself is an illegal assumption of power. The judiciary move these common law theories into the realm of binding precedent, establishing a long record of constitutional enforcement. In the 1892 case Field v. Clark, the Supreme Court emphasized that even the legislature has hard jurisdictional limits on its power. The court asserted that Congress cannot delegate legislative power, calling it a principle universally recognized as vital to the integrity and maintenance of the Constitution. Decades later, the court reaffirmed this strict non-delegation doctrine in cases like Schechter Poultry in 1935. Historically, the judiciary recognized that preserving the republic requires strictly enforcing the boundaries of the delegated trust, striking down any legislative attempt to bypass them. If the rules are this clear, why do so many mistake administrative rulemaking for lawful authority? The answer lies in how we experience government. Most people rely on procedural visibility. Because forms are issued, courts hear cases, and agencies operate continuously, we develop the habit of assuming their underlying authority must be valid. Constitutional visibility demands authority be proven through an unbroken chain to the sovereign people. But trace a modern agency regulation backward, and the chain breaks where the legislature subdelegates authority. An act disconnected from its source is void ab initio, invalid from the beginning. Flawless procedural compliance cannot cure a fundamental defect in constitutional delegation. A usurpation dressed up in administrative paperwork is still a usurpation. The government cannot invoke necessity, emergency, or administrative efficiency to bypass this strict chain of delegation. The ultimate rule of constitutional tracing is absolute. Where the constitutional trail ends, the lawful power ends. We return to Thomas Paine's binary. The American system is a closed loop of delegated trust. Anything existing outside of that loop is an act of force. In a constitutional republic, authority is never presumed. It must be demonstrated.